Good morning, friends of the law offices of Brent Williams-Ruth. I am Brent Williams-Ruth, and I just am getting out of court, which is why I'm all in the official suit and tie to be respectful to the judges and to the court. And now I'm coming to you with a little bit of advice to talk about the step up in tax basis. Now, why am I doing this? Because it's a conversation that came up during Thanksgiving holiday, and I figure if one of my dear friends has this question, maybe some other people do. So first, I'm going to talk about a general hypothetical situation, and after that, I'm going to then pivot into a discussion regarding irrevocable trusts and avoiding the estate tax, because these things are all intertwined. Now, first, I want to mention that I am a Washington State licensed attorney, bar number 32437. I am giving this video purely as an educational endeavor to help people understand things. It is not meant to give you or your family or your loved ones or your friends specific legal or tax advice regarding their own situation. So with all the disclaimers out of the way, let's jump in. And I will say, I even created a little graph because I am not one of these people that's an influencer. I don't have flashy visual effects. Sorry, I'm just trying to help you understand. So let's say your parent purchased a home in 1970 and they paid $30,000 for it. And now it's worth $3 million. Congratulations. They've done a great job. They've lived in the home for 55 years. And now they're thinking, it's a little big. Or I want to move into an assisted living. I'm going to pause and also say that this advice that I'm giving is definitely coming from a position of privilege. The people who can do this are in a better spot than those who are up against a wall. So please, again, this is purely educational. It is not meant to apply to your situation. Talk to your own legal and tax advisors to get the best advice for you. Because if that person were to sell their home, they're looking at a potential capital gains tax of long-term capital gains of about $600,000. $594,000 to be exact. But if they held on to that property until they passed away, and then their estate were able to sell that house, they would get a step up in tax basis, meaning they would pay zero in capital gains tax. So let me show you my little graph. Okay, so see, it says the house was bought in 1970 for $30,000. It is then sold in 2025 for $3 million, but the original owner has that $30,000 tax basis. So you can see down below here, that's the tax basis, that little line right there. Now here's their sales price and there's their tax. And let's be honest, that's still a healthy profit. But if you don't have to pay the government that money, don't. Because again, if you can hold on to the property until you pass away, and then it's sold by the executor after death for the market value of $3 million, the stepped up basis is $3 million. And so there will be zero capital gains. This applies for everything that's an appreciable asset where you can trace back the cost of origin. So think stock. You know, a lot of people will tell you, oh, I bought Amazon at $2 a share in 1999, 2000 when it was cratering. Great. Good job for you. I wish I would have held on to my stock from when I was first getting in. But I sold it at 200 thinking, wow, it went from $2 to 200. That's amazing. Okay. You've got that stock at a $2 per share stock price. If it's sold while you're alive, long-term capital gains if you've owned it for more than 12 months. if it's sold after you die, whatever the market value is on the date of death. So literally, the market closes on the day you die, and Amazon's at $5,000 a share. And I'm, again, making up fake numbers here just for the illustration. Your estate will sell those shares at $5,000 or transfer them to the appropriate beneficiary through a beneficiary designation or a will or a trust. And they will inherit those shares with the tax basis of the closing market price on the day you died. So again, saving thousands of dollars for the long-term capital gain. Now, let's talk about people who say, oh, I don't want to pay the estate tax. Because in Washington State, we do have an estate tax that begins currently at $3 million. It will then be adjusted for inflation on January 1. So it'll go up to 3.1 million or whatever the number will be, but it'll go up. If you have an estate that has more than $3 million in assets, you will be subject to the estate tax. Well, if you were my client and these were your facts and you came into my office and said, Brent, I don't want to pay the estate tax, I would literally create a side-by-side comparison and say, you're just over the estate tax threshold. The first 3 million is exempt. The first 100,000 is taxed at 10%. So you would pay $10,000 after you've died for the Washington estate tax if you had $3.1 million. Now, what's the lesser of two evils? Transferring assets or selling them while you're alive and paying the long-term capital gain of nearly $600,000, or paying the state of Washington Department of Revenue $10,000. Now, the reason I bring this up is if you happen to have an irrevocable trust, one of these trusts that's designed to avoid the estate tax, the drawback is that there is no step up in tax basis. So your trustee will be able to liquidate assets, but if there's going to be a long-term capital gain, it will literally be from what you paid when you purchased that asset. Now, there comes a point where the savings in estate tax is worth paying the long-term capital gain. But again, these are for people who are literally in the tens of hundreds of millions of dollars and above. For the average everyday Seattleite, Washingtonian, King County resident, you're not going to be in a position where your estate tax bill would be greater than your capital gains bill. So all of that is to say, if you have the ability, like let's say grandma's been in her house and she really just wants out, and you as a family can come together and help keep her as the owner of that home until she passes by paying for the assisted living. Maybe she has no other money and the house truly is the only asset, and she wouldn't be able to afford to go into an assisted living facility that she wants without selling the house. Now this is where I was talking about the position of privilege. If you as a family member and future beneficiary have the ability to help out and cover extra costs that maybe her Social Security and pensions aren't providing for that assisted living facility, you will come out ahead by advancing $20,000, which again, you can then include as a expense to her estate that gets offset and repaid. There's all sorts of ways to do this. But if you have that ability, I work with my clients to build the generational wealth that is not done through some tricks or schemes or fly-by-night TikTok that gives you a minute 20 experience that says, this is what all wealthy people do. As you can see, I've already been talking for about 10 minutes, and this is truly scratching the surface. But this is one of the reasons why I counsel my clients that before they ever make the big sales, downsizing, liquidations while they're still alive, that they talk with their estate planning attorney. They talk with their CPA. And with no offense, I don't mean the people at Jackson Hewitt or H&R Block. When you're getting into this type of wealth management and attempts at creating generational wealth that you'll pass to your family, it's worth the investment in yourself to work with a designated CPA firm that does more than a 1040 EZ filing. So, and just ask, if you're working with someone, are you comfortable and qualified to give me the advice on how to manage my assets to have my lowest tax exposure from here through death? Because that's the thing, is that if you have assets and you've invested well and you've held on to property that have grown in value exponentially, it's looking at all of the taxes that you will be subject to. In Washington, we do not have a state level income tax. We do not have an inheritance tax. We do have a estate tax that is paid by an estate before being distributed to the beneficiaries. And then we have other real estate excise tax. So if you sell that $3 million home, not only do you have the lack of a step up in basis, but then you also have the real estate excise tax. So again, don't make decisions based off of TikTok. Don't make decisions just based off of this video, but hopefully be inspired to sit down, talk with your professional team. That is your wealth manager, your CPA, and your attorney, to look at the whole picture and find the path that will achieve your objectives, reduce your tax exposure to the lowest it can legally possibly be, and then know that you've done everything you can to create the generational wealth transfer that you're hoping to create. Thanks so much for watching. And again, as always, if you or anyone you know is a Washington resident that could benefit from talking with me about your estate planning or estate administration needs, please call my office at 253-285-7751. Again, that's 253-285-7751. Thanks for watching and have a great day.